Diana was hurt on the job. Her forearm was fractured. A real injury, a real accident, not her fault. Her supervisor, trying to be helpful, drove her straight to the company's preferred clinic. They walked in. The front desk handed her a clipboard. Standard intake forms, she was told. She was in pain. She wanted to get seen. She signed everything on the clipboard without fully reading it carefully. One of these pages was an arbitration agreement, and by signing it, she had agreed to give up her right to a jury trial if she ever pursued a claim against her employer. She didn't know. Most people don't. And that's exactly the point. I've been handling injury cases in Texas for nearly 30 years. I've seen arbitration agreements show up in the most ordinary, seeming moments, and I've watched injured workers lose significant leverage because of the paperwork they didn't understand. So let's break this down. What arbitration actually is, why your employer wants you to sign it, and what your options are if you've already have signed an arbitration agreement. What is arbitration, really? Arbitration is an alternative dispute resolution process. Instead of taking your case to court in front of a judge and jury, arbitration sends the dispute to a private, neutral third party called an arbitrator. That person hears both sides and makes a decision. On paper, it sounds fair. In practice, for an injured worker in Texas, there are some significant differences from what happens in a courtroom. There's no jury. In a civil lawsuit, you have the right to have your case heard by a jury of your peers, ordinary people from the community who understand what it means to be hurt, to lose income, to worry about whether you'll ever work the same job again. An arbitrator is typically a former attorney or retired judge. The dynamics are different. Arbitration is also typically confidential. There's no public record, no transcript that other injured workers can find, no accountability if the outcome seems unjust. Discovery, the process of gathering evidence before a hearing, is often more limited in arbitration than in court. That can make it harder to build your case, and appeals are severely restricted. In court, if the judge makes a legal error, you can appeal. In arbitration, your ability to challenge the decision is extremely narrow. You essentially live with the outcome of the arbitration. Why non-subscriber Texas employers love arbitration. Now let's talk about why non-subscriber employers in Texas are particularly motivated to get you to sign an arbitration agreement. Texas law allows employers to opt out of workers' compensation. When they do that, they give up certain legal protections. Workers who get hurt can file a civil lawsuit, and importantly, Texas law restricts some of the traditional defenses a non-subscriber can use. That makes civil litigation a real risk for non-subscribing employers. Arbitration neutralizes much of that advantage. It removes the jury from the equation. And I'll tell you from my time on the defense side of these cases, employers worry about juries. When a seriously hurt worker stands up in front of 12 people from the community and explains what happened to them, how their life changed, how they can't play with their kids anymore or go back to the work they knew, juries respond to that. Employers want to avoid that moment. There's also a cost asymmetry that favors the employer. Arbitration isn't cheap. Arbitrator fees, administrative costs, these things add up. For a company with an in-house legal team and ongoing resources, arbitration is sustainable. For an individual worker who's injured, out of work, trying to pay medical bills, the financial pressure of a prolonged arbitration process can be crushing. And there's one more thing worth knowing. Some employers have ongoing relationships with arbitration companies or use the same arbitrators repeatedly. Neutral doesn't always mean neutral in real practice. When and where the agreement shows up. The arbitration agreement can appear in several different places, and it's worth knowing all of them. The most common is the onboarding paperwork. When you start a job, you get a stack of documents, tax forms, direct deposit forms, policy acknowledgments, emergency contact sheets. The arbitration agreement is often buried somewhere in that stack. You sign it on day one, before you've ever been hurt, before the question is even real to you. And then a year or two later, it's sitting in your file. The second place is what I call the clinic moment. Exactly what happened to Diana. You're injured, in pain, and someone hands you a clipboard of forms to sign before they'll treat you. This is a particularly concerning setting because your judgment is compromised. You want help. You're not in a position to read fine print carefully. Third, post-accident emails. I've seen this multiple times. The day after an injury, someone from HR emails the worker a packet of documents with a note like, please review and sign, and the arbitration agreement is in there. It looks administrative. It doesn't announce itself as something significant. And fourth, implicit pressure. Some workers are told, directly or indirectly, that signing the agreement's a condition of continued employment or continued coverage. That's a form of coercion, and it matters legally. Does the agreement actually hold up? Here's the thing that surprises a lot of people. An arbitration agreement is not automatically enforceable just because you signed it. Texas courts have looked hard at these agreements in the context of employment injuries, and there are a number of grounds on which they can be challenged. Unconscionability. If the agreement is so one-sided that it shocks the conscience, courts have declined to enforce arbitration agreements. Lack of mutual obligation. If the agreement only binds the employee and not the employer, or if it allows the employer to bypass arbitration for the types of claims they want to pursue while forcing workers into it, that asymmetry can be grounds for challenge. Procedural defects. If the agreement wasn't properly disclosed, if the worker wasn't given adequate time or opportunity to review it, if the agreement was buried in a way that a reasonable person wouldn't have recognized it, those are all facts a court will consider. Coercion. If you were told you'd lose your job or your medical treatment unless you signed immediately, that's relevant. Now, I want to be clear. I'm not saying every arbitration agreement can be thrown out. Some are well drafted and will hold up. The point is that you need an attorney to actually look at the document, not just assume it controls your case and move on. I've seen workers give up before the fight even started because they assumed the agreement was bulletproof. Sometimes it's not. What you should do. If you've already signed an arbitration agreement, the first thing I tell you is, don't panic. Don't assume it's over. Get an attorney to review the specific document and circumstances. The analysis does matter. If you haven't signed the arbitration agreement yet, or you've been injured and someone is now asking you to sign new documents, slow down. Tell them you'd like to review anything before signing it. You don't need to be confrontational. Just ask to take it with you or say you want to show it to someone first. Be particularly cautious if anything presented at the clinic or doctor's office after an injury. Some of those documents are genuine medical intake forms, some are not. They shouldn't all look the same to you, but often they do in the moment. And even if you end up in arbitration, even if the agreement holds, having strong legal representation still matters. The quality of your case, the evidence you've gathered, the way your damages are presented, all of that still influences the outcome. Arbitration isn't a guaranteed loss. It's a different venue with a different dynamics that requires preparation. In my nearly 30 years handling these cases, I've helped clients who signed arbitration agreements before they ever knew what the document meant. The story doesn't end there. I hope this gave you a clearer picture of what's at stake when someone hands you paperwork after a workplace injury in Texas. These documents have real consequences, and the circumstances in which they appear are often designed to minimize your scrutiny of them. If this was helpful, the next video I'd watch is the one on light duty setups. After the early paperwork games, many employers move to their next tactic, putting you on light duty in a way that sets you up for termination. That video covers exactly what to watch for. And if you're already in this situation and need to talk through your options, our number is below.